Welcome to Talking Legal with Templars. My name is Femi Oyewole. I'm a senior associate in the dispute resolution practice group. Today I have with me Sadiq. Sadiq is a partner in our dispute resolution team and a partner in our media, entertainment, and technology practice area. Welcome, Sadiq.
Thank you, Femi.
Today we'll be discussing data protection in Nigeria, the legal framework, and the frequently asked questions. It's been a prominence in conversations around data protection in Nigeria. Can you talk us through why there's so much talk about data protection in Nigeria?
Thank you very much for that question. It is true, data protection has gained a lot of global prominence in recent times. And for me, the reason is not far-fetched. From an economic perspective, data has become the new oil in terms of its rapidly growing importance and value in the global digital economy, which is why you see today the richest companies in the world are arguably the big tech companies. And the reason for this is because data generally is central to the work they do. So, which is why data protection, for me, has gained some level of visibility across the world. Now, on what data protection is all about, I think that the incursion and the exponential penetration of technology to our lives and the application of technology to almost everything we do in life, be it our private lives, our businesses, social interaction, and the conduct of government businesses. We rely on technology to do almost everything. This scenario has made personal information about individuals freely and readily available for use. And this has sort of exposed such personal information to abuse and manipulation by those who are in position to collect, store, distribute, and even alter such information. Now, to stem this ugly tide of abusing personal information of individuals, governments of different countries around the world took it upon themselves to step in to make rules, regulations, laws, right, that would make provisions for obligation of those who collect and process data, personal data, and create rights for data subjects, right, and create an environment where processing of data will be lawful, fair, and transparent. So it is such laws, obligations, legal framework, right, that guide the processing of personal data, that data protection is all about.
Okay, thank you for that. That is a lot to unpack. But before I go into the various persons and personnel that you've mentioned, what is the legal framework for data protection in Nigeria today?
Yeah, the legal framework for data protection, a data protection ecosystem in Nigeria has had a very checkered history. In 2019, the National Information Technology Development Agency, Enacted, took the bold initiative of enacting a subsidiary legislation, which is the Nigeria Data Protection Regulation, right? This regulation was quite robust and arguably one of the most comparatively comprehensive piece of legislation on the subject, making provision for obligations of data controllers and those who process personal data, defining who data subjects are, and making provisions for the obligations of data processors and data controllers, as well as providing very robustly the rights of data subjects, as well as the ways of lawfully processing personal data, right? But because that piece of legislation was subsidiary in nature, and it had its own shortcomings, because some of the provisions did not derive from the provisions of the Principal Act, which was the act creating the agency itself that enacted its regulations. So there were problems. Because of the problems, people continued the clamor and agitation for a more robust, self-sustaining, and more sustaining legislation. This continued until very recently this year, in June specifically, 2023, when the president signed the Nigerian Data Protection Bill into law. Okay. So that from that moment, we now have a new legislation in place.
Okay. Fantastic. So before we get into the law, you mentioned data processor, data subjects, data collectors. Can you just tell us, from those of us that are not familiar with the subject, who these individuals are?
Yes, beginning with data subjects. Data subjects are natural persons who are directly or indirectly identifiable with specific reference to some identifiers like personal names and addresses.
So I'm a data subject.
You are a data subject. I'm a data subject as well, right? Absolutely. Then they have their locations, locational addresses, email addresses, photograph, etc. Right? Then data controllers are those persons or corporate organizations, right, that determine the purpose and the manner in which personal data is processed. Whereas the data processors are those who process, such as collection, storage, or distribution of personal data for and on behalf of data controllers.
Okay. So what are the rights of data subjects in Nigeria?
Yes, good question. Right. One of the things that the legal framework, whether under the regulations of 2019 and the new law, which is the Nigeria Data Protection Act, right, has brought to bear, is making robust provisions for the rights of data subjects. One of the rights you will find on either under the regulation or under the new law is the right of a data subject to have access to his personal data in possession of a data controller. Another right is the right to be informed. A data subject has a right to be informed of the nature and the quality of its personal data in custody or possession of a data controller. Another right that inures to the advantage of a data subject under the law in Nigeria is the right to deletion or erasure of a personal data. For example, a personal data that used to be relevant for a particular purpose, and the purpose is no longer there. So the data subject has a right to demand that the particular piece of data or information be deleted. And this is akin to the right to be forgotten, which is provided for under the General Data Protection Regulation that operates in Europe, right? So a data subject exercises that right where, for example, he previously gave consent to the processing of his personal data, and this consent had now been withdrawn. And there is no longer any legitimate basis for the continued processing of the data. He has a right to request that it be deleted. Then there are other rights, for example, the right to data portability. This operates in a scenario where the data is automated, right? It's stored in an electronic form. The data subject has a right to demand that the data be put together and transferred from one data controller to another. Okay. Yes, the right to data portability.
Okay. Thank you for that. So I've heard you talk about the NDPR and then the new Data Protection Act in Nigeria. Does that mean that is there a conflict between these two laws, or do we just have one law dealing with data protection in Nigeria now?
Well, that's a good question. The scenario here really is that the new law with regard to its transitional and saving provisions are sort of saved, right? The laws that existed before its commencement, before it came into being. The NDPR with its implementation framework is still in force, and in fact, other laws that either existed before it coming into being are still in force, and they will continue to run alongside the provisions of the new law to the extent that they don't conflict. They are not in conflict with the provisions of the Act. Okay. The moment there is a conflict between the provisions of the Act and the provisions of the regulations or the other law in force, the provisions of the new law will prevail.
Thank you for that. In respect of the new law, what are some of the major highlights of this new law?
Yeah, easily the one that comes to mind is the introduction of the Nigeria Data Protection Commission, which is the new regulator, charged with the responsibility of administering the provisions of the new law, as well as ensuring initiation of policies, guidelines, and regulation, right? That would crystallize in the smooth implementation of the data protection ecosystem in general. The second one that one will also consider is the introduction of new entities called the controller or processor of major importance. What we had before now were just controllers or processors.
So the general applicability.
And now you now have controller or processor of major importance with additional responsibilities. For example, they are mandatory required to appoint proficient data processor officers, in addition to having to now register with the commission. Now, in the case of a breach which is associated with the controller or processor of major importance, they have to pay a higher fine
than what they used to pay.
Now, another feature that you find in the new law is the new standards for processing data in respect of children. Right? You now have a requirement where anybody that is below 18 years, right, and is required to give consent for the processing of their personal data, you will have to first obtain the consent of their parents or legal guardian. For that to be effective. Not forgetting the introduction of very streamlined enforcement mechanism, which is in twofold. You have administrative as well as judicial enforcement mechanism under the new law. Administratively, the Commission has a responsibility to issue enforcement orders such as warnings, demands, requests, compliance demand requests, as well as a Caesar disease directive to erring processors or data controllers. Where they fail to adhere to this directive, the regulator also has the responsibility to impose fines following from prior investigation. Then judicially, following non-compliance, which has been consistent, under the law, such non-compliance as the consistent qualifies as an offense, which is punishable upon full trial and conviction. The punishment is either a fine or a jail time to the erring processor or controller. Yes. So these are the in a nutshell, there are so many, but these are the ones that easily come to mind.
Thank you very much for that. That is very helpful. In terms of your projections, the way forward, now that there's a new law, how did you see this going?
Yeah, I see a lot of work coming from the Commission in terms of implementation initiative. I see that I see the Commission initiating guidelines, general regulations that will be geared towards the smooth and seamless implementation of the spirit and letter of the law. Because, like you do know, there's no law that can be made to cover for all situations. So, as the Commission carries on with the implementation of the new law, where there are gaps, of course there are gaps. I expect that the Commission will initiate policies, regulations under its powers to cover for such gaps and inadequacies. Then, secondly, I see a lot of collaboration on the part of the Commission with sister agencies, right? Partners for the smooth and efficient implementation of the provisions of the law. For example, you will have observed that in very recent times, the Federal Competition and Consumer Protection Commission, the FCCPC, has been very busy trying to clean up the digital lending space, right? That is an area that I see a lot of synergy between the Commission, the regulator, and the Commission going forward. I also see a lot of collaborative effort between the regulator and the NCC in terms of areas that border on on telecommunication information, right? As well as the Central Bank of Nigeria when it comes to digital banking or finance issues. Right? I see a lot of collaborative effort going forward.
Okay. Thank you very much, Sadiq. This has been very insightful. I now understand the regulatory framework for data protection in Nigeria. Understand that there's a new sheriff in town with a bite as well. And we can expect more directives going forward. Thank you very much for your time, Sadiq. This has been Talking Legal with Templars. See you next time.